So let me dive into the RACLA. Leases Act. It's divided into various parts. Interpretation part one. Part two, we have certain obligations that have to be carried out by a landlord. Four deals with security deposits, bank guarantees. So you'll see, in fact, that we've actually reproduced this paper mostly in the materials. I'll just be speaking. Won't be reading it out. With me in this talk. Paper. But for a range of stipulations that what a retail companies can do, there are important regulatory safeguards in the RACLA. So tenant cannot be excluded. Lease. 5 outgoings, and you assess and recover outgoings, but central as corporations to premises. Do, just noted. 7 assignments and termination. What happens on assignment, specifically around the ongoing liability of the tenant in the guarantee clause of a tenant. Other parts relating to specifically on a retail shop lease, which is in a shopping centre, on dispute resolution. So, some of these things you probably already know, some not. Some things you may know a bit about. So the current RACLA, a little bit torturous upbringing. There was in 2013 a loss review on the retail sector, and there were recommendations made in that review. A mere 7 years later, the RACLA was torn. Forms for a long time. I will be approaching this talk from the perspective of a tenant who would like to be a small business owner, but landlords as well, I suppose, and that's just the flip side. So coin. It does, as I mentioned, contain important regulatory provisions that relate to small business tenancy. So the first question is, when does the RACLA to retail tenancy? It will apply if, subject to some qualifications, if the rent paid is less than $400,000 a year, excluding GST. So above that, it won't apply. Below that, it will apply. Subject to some qualifications. That $400,000 limit used to be $250,000. And in 2017, there was a case called RACLA nominees. That case involved a lease that was entered into. At that stage, the threshold was $250,000. For the landlord, granted a lease of $250,500 above the threshold because he wanted to insert a ratchet clause into that lease. Ratchet clause is a clause by which a landlord can adjust rent to the greater of A or B, and if so, which one's longer greater. So that's what that's. That's the law for them. It's the law for not enforced. Please grab some lunch. So the idea was that this lease in DACO would purposefully set so that the existing act at the time did not apply 2 years. Commenced was that threshold hit above 250, 400. So all of a sudden, the lease which started out life as a rent, but slightly above the threshold, now found itself below the threshold after the lease commenced. The question then was, well, does the act follow? No, because when the lease was created, not but halfway through the term, ordinarily if the lease has been granted, that lease debt won't apply to. So that is that was one trick. The court decided in fact that in that application for that lease, which was a bit controversial because that brings up the concept that an act can just appear or not appear. So implied and mixing with the not right. That matter was put to rest by RACLA and settled really in favour, I guess, of the tenant, so that if you have a lease in which the rent is more than $400,000 do it, then to me go down, for example, threshold goes up, it commences to apply, then that's what happens. Perhaps an unusual situation in which you may be wanting to interpret a particular provision in the lease or determine whether some provision is lawful or not, or the act can be taken advantage of or not, and it's largely dependent on the matter of timing as to whether it's having some application disappear. And it can go either way. Yeah, it's not really been tested in any litigation. What would happen, for example, if you had a lease in which the landlord could recover land tax, which at the moment would be, then the act ceases to apply. So maybe because the rent's threshold or it's in a slum or a company, for example, then there's also the act. It's got applied and that provision. There are other situations in which the Act may not apply and will not apply to a retail lease. That is, where the term is for 1 month or less, or the right of occupation rights to the some business, something like that as part of their contract, or the tenant is a public company. The Act also won't apply to a lease which is registered within 3 months if the rent is above the threshold and the lease is registered, notice that tenant, and even if the rent falls below the threshold, where you would deduct over the threshold to it doesn't. Circumstances in which this thing kind of jumps in and out of operation. On the issue of whether the tenant is a public company, if it's a public company, the Act will not apply to it. It could be a subsidiary of the public company. Sometimes that's difficult to work out. I recently advised on a lease involved street sales. Turns out that company is owned by and oversees what appears to be a public company, but who the hell knows. And we had the Act applied to specs over the lease. Ultimately, we thought it would, but we weren't clear about that because we just couldn't work out what the ultimate ownership of specs overs was. The important thing to know about the Act is that it imports certain provisions into a lease that can't be excluded other than limited circumstances, which means that whatever the lease says, there are provisions in the Act that mainly provide protection to a tenant which can't be overridden. For example, this ratchet clause. There's also 2-year maximum liability in connection with the assignment of a lease. Those things. When you sign a lease, you have a typical occupation. On the subject of how do you structure a lease as your landlord, for example, perhaps a clause where you want the 2 ways of working out rent. I'm asking sometimes, well, do we put it in anyway because the Act required it? I think, well, yes. Put it in applied. Put in the lease that says the land tax. I've had people say, oh, we can't do that because it's void. Well, this makes it void. Might one day not be void. So you can put things into a lease It may not be enforceable, but it's not unlawful. It just means it can't be enforceable. Right? And that's generally what you want to try and do. And so just because there might be a provision of a lease that's tipped over as not being enforceable, doesn't mean. Okay, so the next thing to do is determine what a retail shop lease, what a retail shop is. And a retail shop is business premises which are sold to the public by a retailer, or which services are provided to the public, or it's business premises in which the public are invited to negotiate for the supply of services. It's not an entirely straightforward definition. What does it mean to have retail premises in which the public is invited to negotiate for the supply of services? Does that mean the public actually have a tenant? Then you have business premises in which you run an internet operation in which you never see the public at all. Is that premises in which the public are invited to negotiate for the supply of services? Not possible. So there can be some uncertainty as to what a retail job actually is. And I done this recently. What does it mean that goods are sold to the public by retail? Or you have a shoe shop? Sure, that's a sale of retail. I advised on a matter recently in which there was a wholesale market that was closed wholesale vegetable market stores. I was asked to advise on whether a land act, which was considerable, several $100,000 from all of the tenant, all the store owners, and did the act apply to them. So each lease said tenant is not allowed to sell anything by retail. Fine. That's what I actually asked the question is, are they? Well, my view about that, of course, ultimately just have no one to tell, because there were days in which the public would attend Sunday. Every to go attend. If I buy a whole quantity of stuff and I take it home, consumption, that's a retail sale. If on the other hand I'm a restaurant owner, I buy a whole quantity of stuff and take it from a restaurant, that probably isn't. The guy selling it to me has no idea. How does he know what I'm doing? Unlike take it from a restaurant, I might take it home. I mean, there's no way of knowing. So the mere fact that the lease said that the tenant can't make retail sales didn't mean that he wasn't making retail sales. And I think that if the fact making was such that you could say that retail sales were being made because items being purchased at this wholesale market were in fact for final consumption, which plenty were, then they're retail sales. Yeah. Fortunately, we never got to test that. So this whole idea about just what a retail sale is can be okay. So before a lease is entered into, people with this, you need to give a disclosure statement. Well, it's offence not to do that. The landlord has to set out a whole bunch of things. There's a copy of the disclosure statement of regulations. Details of lease, rent, areas, all that, lots of things. All the regulations. I won't go through all of those now, so they're extensive. Methods of calculating rent, monetary obligations, obligations for repairs and maintenance, all those things. And that's slightly expanded in the context of the shopping centre, or at least within the shopping centre. And the shopping centre broadly is something which there are, I think, 5 tenancies and it's owned by one person, everyone's retail property. In which case, you've got to get details of parking spaces, facilities, contract. And if you're wondering what happens, those disclosure statements is not coming quite right. The court has wide power to make orders. So the purely false in the disclosure statement, they can cancel the lease, they can make orders for compensation. So they're not There's a provision that makes void an obligation to make capital contributions, unless they're called permissible obligations. This obligation is an obligation to make good damage to the tenant, or if there's a requirement to fit out a shop, we've often had as a shopping centres and some positive obligation to fit out and regular reports, those things. Or there's an obligation to contribute to a single income. But beyond that, you can't make a tenant, you can't be made to make replacements. Likewise, an obligation to reimburse for depreciation can be forced against the tenant. Depreciation is arising from fair wear and tear, that is. Fair wear and tear is a deterioration of premises brought about by the ordinary application of performance without necessarily some specific intervention by it's arising from the ordinary use of premises, etc. So backing a forklift into a roller door, not the fair wear and tear, but ordinary damage or interference arising from ordinary use of fair wear and tear or the application of the elements. That can be taken into account, fair wear and tear rather, can be taken into account in determining things and should do that. Certainly, market dependent for parts of the act that deal with damage and you can take into account fair wear and tear, deterioration arising from fair wear and tear. These preparation costs, you're probably aware, you can only be required to pay, or tenant can only be required to pay half of these preparation costs. Can't recover a premium for the grant of the lease, so you can't say to us, I will grant you a lease as long as you give me a premium. I've seen it done. I was involved in about a recent the substantial premium paid to the government to grant lease. That's different. Generally, though, it's the other way around. Landlords incentive to a tenant in consideration of the tenant into a lease. Incentives can be payment, fit out, other things, rent-free can be an incentive. I think to bear in mind the incentive is that if it's a cash payment, an incentive will be assessed income straight up. 2631 affluent. So if you're attempting to avoid receiving a cash payment consideration granted lease or lease, it's flat out assessable, deductible to the landlord. That's one issue as well. So that's very attractive for landlords. Otherwise, if you're paying for some capital works or a fit out or something, his benefit would just be to appreciate all of that, which is less attractive than the straight up deduction which is paid. So, there's an implied fitness for purpose warranty, and if a landlord has some notice that a tenant is required for some particular use, then there's a warranty given unless it's excluded by the premises fit for and structurally suitable for that use. Recently advised to grant them into a lease to for crash repair. Turns out that half of premises had been built with no development. The tenant was getting into it, the landlord. And so my client has some plans to do a few things, but we soon worked out that the council was in half the building because without approval. We said that the tenant, the landlord rather, we're walking, going, leaving. Broadly, there was nothing to do about that because it was a flagrant breach of warranty. It was not fair. So that was an example of that one. Let me talk about security bonds and bank guarantees. So, the Act deals with security bonds. Security bond is a cash payment of an amount, and it's limited to 3 months. It can't be any more than 3 months exclusively to students. Criminal offence lasts for more than that. And so that's commonly done. A bank guarantee is different. Bank guarantee is simply a promise by the bank to pay money. That's what it is. There's no the bank guarantee must the margin. See, that's time. And as long as you've got the original, what do you have to do? To qualify in any way, that's the reason for how you're doing this. It's just prompt. Well, and there are parts of the Act that deals with the treatment of security deposit and treatment of bank guarantee, and they're not the same. For example, there seems to be no limit to how much a bank guarantee can be. In the case of a security deposit, that's been months. 6 months, 3 months, anything. No, it doesn't seem to be. A security deposit needs to be paid to the Small Business Commission. And it's actually quite a serious case. And the Small Business Commissioner then basically has jurisdiction on what happens to that security deposit. And I think right from that is that if a landlord wants to claim against it, then he's got to make an application to the Small Business Commissioner. If there's some armrest going on as to whether it should be returned, then that goes to the Small Business Commissioner, etc. So it provides a level of security to the tenant that its security deposit is in safe hands as opposed to none of those things apply to a bank guarantee. Bank guarantee should be kept. And it can be pretty much cashed at any time. I'm not even sure, well, say, landlord could cash it even if there's no breach of lease. And in theory, but it shouldn't exactly be a breach of lease, but in theory, do it. There are provisions dealing with the return of the bank guarantee. And the landlord who receives that bank guarantee is to return it within 2 months after the lease, until they see completes the performance of any obligations which the bank guarantee is provided as security. So he can just hang on to it. Significant penalty breaches that obligation. And if a landlord fails to, he's liable to damages, sorts of things. So I guess if we contrast the two of these things, security deposit is likely to be more expensive for the same amount than a bank guarantee because you're going to be borrowing money to tend to pay the security deposit, or you're going to be taking out, losing the reinvestment amount of it. And I don't think you get interest on 6 months. So it's going to be more expensive for that. But on the other hand, it's limited to 3 months, and the Small Business Commissioner has some jurisdiction over credit. And the landlord comes. Bank guarantee, on the other hand, even though I understand it, still with them likely to be cheaper in terms of a financing cost, but it can be open-ended as to the amount. But there is good doubt in the future as to when you actually get it back, because it depends upon when it can be said that the obligations which the guarantee has been provided have been met, particularly in the context of assignment. And the landlord can just go to every 5 points. So it's kind of a pluses and minuses on this. I think there is a difficulty coming up in the context of an assignment. So if you're a tenant, given a bank guarantee or even a security deposit, assign to somebody else, Well, what happens to both of those things? I think bank guarantee just stays what it is. Just explain it. No particular reason why he has to give it back, because the obligation under the lease for the guarantee has been provided hasn't been completed yet. The lease is ongoing. I think that's problematic because the owner becomes tenant, then loses control over the tenant. It's off bringing a caravan around Australia, whatever it may be, and he has no idea what it is. So probably you want to include in the lease a provision that says that on an assignment, the landlord has to return the bank. Well, probably in return for the incoming assignee providing the guarantee. That's similar with a security. There is a provision in here which is an unusual one. It provides for a minimum 5-year term. But the term of a retail shop lease has to be at least 5 years. So what that means is that if you have a lease for 3 years, 2 years, then the Act says that's not, it's 5 years. Which is interesting because if your lease actually says 3 years, then what do you do with the rent next for 2 years? That's not clear. Probably the position is that the rent just rolls on somehow, but if you've got provision for rent increases, say in the first 3 years, what about the extra thing that they had? I mean, I think it has to be implied that rent is payable. It actually doesn't actually say that. It just says that it's for 3 years. 5 years. Probably what it means is that the rent just kind of rolls away. I said, no. So you can exclude this by way of a certified exclusionary clause, by which the tenant goes to see the lawyer says, yeah, this is fine you, the tenant says, yeah, I understand that, away you go, and it's fine. So be careful with that. Also, a tenant, because that's the custom of there will be this, I found this case magnificent of the Hosanna Excelsius One Universal Church in Pasadena. So what happened was that there was a lease granted to the Hosanna Excelsius One Universal Church. They just sort of walked into that. So they haven't said, no, you've got 5 years. You're not going to. So it cuts the other way. That was actually, I think, the church, Hosanna Excelsius Church, won that one on technical grounds that they were going to. That's what. Okay. This is a bit of a grab, I suppose. I apologise for that. There are parts of the Act that deal with preference that has to be given in the case of a shopping centre lease. And shopping centres really got leased on premises and also. So if a shopping centre owner wishes to re-let premises or a tenant, he either has a right of preference or he doesn't have a right. He'll have a right of preference. He won't have a right of preference if there have been substantial breaches of the lease, or things, or if the landlord wants to do the tenancy mix, or whether the otherwise he has a right of preference. If he has a right of preference, then he needs to offer to the tenant, make an offer to the tenant on the same terms as he is offering potentially somebody else. If he has no right of preference, because he's the lease, for example, then he's actually got to just make that statement. The tenant and explain why. Particularly the tenant has signed, of course, will right to go off and agree with that. He just has to say, not that I like you, just that you don't have a right of preference, these reasons, and then he doesn't have the but if there is a right of preference. And before entering into a lease with someone else, you've got to make a written offer, extend the lease for no less favourable terms than this offering the next guy, and those negotiations then continue. So, what happens if he doesn't do that? If the landlord fails to negotiate in that way for someone that has a right of preference, the tenant can say, well, you haven't offered me what you meant to. I have a right of preference here. You haven't done that. So the term is now extended for 6 months by operation of Section 20D, in which time that negotiation has to continue. The tenant can simply terminate on must at any time during that time, but the landlord. So he's stuck in there for an additional 6 months. So if you're the owner of a shopping centre, it's a fair incentive. Going through that process of, in the case of a failure to comply, the Small Business Commission being mentioned was I should say, I should have said at the start of the letter, where you have a shopping centre. When you don't have a shopping centre lease, so you're not dealing with that, and not less than 6 months nor more than 12 months before the end of the term, you need to give to the tenant notice, offering or advising that the landlord not going to be offering renewal. And the landlord basically has to tell the tenant what their intentions are. Again, if the landlord fails to do that, then the term of the lease is extended for 6 months while that happens. There are provisions that deal with the recovery of rents and outgoings, and if the tenant's liability, so if a landlord has some obligations to do some work, fit out obligations, those things, within retail premises, has that obligation. Tenant's liability to pay rent is basically suspended until the landlord's done whatever he's supposed to do. So if you have a lease commencement date, the landlord can't say to the tenant, according to my lease, which you have to start paying rent, if he has outstanding obligations that hasn't been. There are some restrictions on adjustments of rent. A mechanism in a lease by which rent is adjusted when it is not certain, which etc. Within 12 months of the last adjustment, could have written that says we will adjust the rent by 2% every 6 months. That's fine, because that's specified, that's understood. Where it's not understood or not capable, then that's not enforced. As I mentioned, RACLA clauses can't be enforced. Discuss those. That's where and there are some interesting provisions on way market reviews. So there are some provisions that are added in dealing with how market reviews can be done. You have to take have regard to the terms of the lease and rent that you could reasonably expect if the shop was unoccupied and not good for renting. So in determining what a market rent is, you need to assume that the rent is on. That's important. Sorry. Second, you've got to discard the value of goodwill created by the tenant's business, those things. And if they don't agree, then you have the opportunity to fix the rent. So I mentioned that you value premises as if it were unoccupied. And the reason it's important is that valuer can take into account incentives offered in the marketplace to attract a tenant. that has the effect of reducing. If a rental, market valuation of rent takes into account the value of the percentage, which is normally a percentage of rent, that has the effect of reducing what the rent is. Fair to do that. It's not entirely clear, but I think that if the stipulation is that the parties were evaluating the current rent, paragraph for terms of use, that's fine, that's fine. Be expected to go unoccupied implies that they were used to take into account their incentives. That's a little bit unfair to landlords actually, because if the tenant is already in occupation, it's exactly the same thing happens on your lease as well. So if it's a market review during the lease or on a renewal lease, either way, they're often for the lease, then why should the valuer assume it's unoccupied? Because it is occupied. It's there. So that's kind of a bit unfair. That seems to be, I think, how it would work. If you're a landlord, you probably want to put something in. So they have it settled on your side of the line. Provisions as to how outcomes can be recovered. Got to provide details on what outcomes can be recovered. If there are outcomes that are not specifically directed, but therefore, such as building, which we just tend to plan tenants, so in other words, it's not specific to a tenant. It's has to determine how that is apportioned. It's normally apportioned on a GLA or a area measurement that would be common. All that needs to be spelled out. Can't recover land tax, which can have land tax to account. Determine what it might be. And at the commencement, as I mentioned, the landlord has to give an estimate of outcomes, just disclose a statement. Penalties for not doing that. There's a requirement also in 3 months at the end of each accounting period to give a statement of the outcome, treatment of outcomes. It's really done in semi-audit. And at the end of that accounting period, you need to make adjustments. So there's fair rigor around how outcomes are. There's an interesting provision, section 36, dealing with the determination of the market rent. Tenant or retail shop lease can say to the landlord, got a renewal coming up, it's a market review that happens on a renewal, but I don't know whether I want to renew because I might have been downgraded. So he can do that. He can request a determination of rent before a renewal is exercised. And the landlord has to undertake that market review and agree it or have it determined. And if it is agreed or determined, bear in mind the tenant still hasn't actually exercised the renewal, then the tenant can either choose to renew or not renew. If he does renew, then the rent that's been determined or agreed, that's the rent. So that's a useful thing on behalf of a tenant. There is reason dealing with compensation for disruption. There are common law obligations to quiet possession. It's quite deal with them. Litigation arising from that would be, for example, shopping centre with a mall, landlord stick a bunch of kiosks down there. That's a question. And a tenant can be compensated for disruption. There's some inhibition of access, inhibiting flows of customers, those things. So, if there is a failure to rectify any breakdown of the plant equipment, under the lessor's care or maintenance. I had litigation recently in Queensland, UCAT, Queensland Civil, and there was a big fight over my client landlord's obligation to place a considerable cost air conditioning for its childcare centre. The other side will rely on this, but we're able to allege, prove that all that air conditioning plant was not within our care and maintenance obligation, because the tenant hadn't. So at that point, won that action on that basis. So if you're a tenant, you probably want to make sure that the items of plant, things within the landlord's obligation for care or maintenance. You don't have that obligation because those key capital replacements are trivial. The matter of this matter of Queensland. Interesting thing there was that if we could establish that the landlord didn't have an obligation to replace the air conditioning, then it turned out that no one had that obligation. We didn't. We were never elected to tenant, did. No one did. Well, let's get hot up there. So the tenant actually has an impact on it. But I think the position you get to is that no one's got the obligation. Oops. So there's a provision about abatement. Abatement is what happens when premises are damaged. That's not pretty straightforward. So production breed damage. So things are ordinary type common law spaces like that, or that have been codified. Dealing with assignments, there's a bit of complexity there. This is the ability of a landlord to withhold his consent to an assignment lease. So, the landlord can withhold his consent to an assignment lease. The assignee wants to change the use to which the shop is put. What does change the use mean? Lease will have a use of premises provision. Landlord's point of view, you want to make sure that use of premises type description, what from is it? Lease, what activity is it? Is as narrow as possible. So that, for example, if I wanted to be a shoe shop, and I'm just going to call it a shop, that's not a bakery, it's not a very shop, it's a shoe shop. And I think what that means is that it gives me a fair degree of discretion if the tenant wants to sign the lease to. That's actually it means I've got a greater range of discretion. On the other hand, if you're a tenant, then your best position is to say that the use of premises is a retail. That's the worries. And that means that if you're running a dress shop and you're assigned to a shoe shop, I think, yeah, we'll give us something there, but I think that's probably what can't be limited to the other thing is, the other ground on which a landlord can withhold consent to an assignment is that the assignee is unlikely to meet the financial obligations of the lessee under lease. What does that mean? The obligations of the lessee under lease are probably just one. That's its obligation. I've advised on assignment provision going into leases or lease. Quite recently for a small set of network operations limited terms, which is exactly what we thought. And we had a bit of an arm wrestle on what this meant, financial obligations of lessee, because what both leases wanted to do is to import these provisions even in the active employment. They just wanted to have this And meeting the financial obligations of the lease, if that just means that you pay the rent or line for 3 weeks, I mean, an entirely different question is whether the SME is the same financial standing. So if you're a landlord, you want to keep them up a little bit. So not only you require to income in but you want that person to be of the same financial standing. Substance. I don't know that many companies have some financial horsepower. So that's a greater barrier. That gives you a better discretion if you're a landlord as to who you accept assignment from. Because in the case of Woolworth, for example, you don't want to be, you're a landlord, you own a centre to Woolworths. You don't want them assigning to an entity that sure they can pay the rent. It's about we covenant. On behalf of the tenant, then you're probably okay with that. So you might even say that meeting the financial obligations of their SMEs, they can pay the rent. It's a much lower standard. It's much lower. See the tension there. And there are some provisions dealing with what happens on an assignment. You've got to provide a copy of disclosure statement that becomes a whole lot of hoops. Circumstances in which they seek to require an assignment to be consented to are quite restricted. Follow all those procedures. And that moves me on to the question of the liability of a tenant after an assignment. Basically, what happens is that if a retail shop is a tenant, is to be assigned, or he's assigned, you have a guarantor as well. Ordinarily, they will have an ongoing obligation, so that if the lease has 5 years to go, they are still liable as a tenant for the next 5 years, even if they've assigned the lease. Signing the lease is this provision, however, says, well, as long as you do all these things you need to do, your ongoing obligations to tenant and the guarantor for that matter is limited to 2 years beyond the assignment. Beyond that, you don't have liability. But you've got to do a whole bunch of procedural things. You've got to get a statement, you've got to get a disclosure statement, you've got to find that the landlord do, get information about the breaches, a whole bunch of things. Generally, people they just think this 2 year thing doesn't you run through that process. So if you're a tenant outgoing, assigning on the side of the business, for example, you need to dot some I's and cross T's with this. Otherwise, you'll find that your 2 year envelope isn't there. You won't have that 2 year protection. And from a landlord's point of view, he's not particularly in this because he will have a lease related information. I think the position of a guarantor is quite tricky. This is someone who's guaranteed a lease by the tenant who's signing. If the tenant assigns the lease, the guarantor may never know whether all of these procedural requirements here can actually carried out. There's no way to know. There's no way of controlling any of that. So depending on circumstances, a guarantor may have a continuing obligation or may not have a because it's the assignee, the tenant, that has to do all this stuff. Then the guarantor is nothing. He just sits there. You can probably fix all that up in terms of some documentation, but do it in advance, particularly if you're guaranteeing the lease. Just to say, you may find this step in these procedural obligations here has the effect of preserving liabilities guarantor beyond 2 years. Finishing up, I guess, with some additional comments around the shopping centre. I won't go into things too much, but there are some further restrictions on how relative operators physical information. There's a restriction on ability to close obligations of advertising, and advertising. You can contribute to the advertising budget, but it's restricted that. Restrictions on relocation. How a landlord relocate senior citizens and shopping centre. That can happen. Obligations are. In fact, rising on this at the moment in the shopping centre state. And my client wants to relocate this big council facility. This spot down the road in the centre. Council fiercely objected. At the moment, we're just having an argument. I think they've actually accepted the obligation to relocate. They really have to. Otherwise, they have a termination. So we don't like what you're putting. So they don't want to do that. So they're really forced to accept them. But they want to spend billions. It's just not part of this. So we're just having a bit of exchange of lawyers at the moment saying, look, so if you're a tenant in prospect has been relocated, just watch the occupation. I think that's a bit, it's a bit obscure, but it does happen. Finally, we'll wrap it up. Dispute resolution, often the commissioner, often the magistrate court, be there. That's not how that works. Dispute resolution. And probably, but then you go to the small business. So I'm going to stop it there. Thank you. And I'll just ask any questions.
Is it applies to accommodation, hotels, caravan parks?
Well, business premises.
And in particular, if the caravan park is a residential park rather than open to the public, as is that changed?
Yeah. Look, my feeling is no.
You know, the old previously of advisors. Yeah.
Look, it needs to be business premises. Well, I think it is that.
Well, it's long-term residential.
Yeah, which are sold to the public by retail, no. Services offered, maybe.
Is it public?
But I think probably the term of the tenure isn't enough. I think it's less than a month. So I think probably no on that. So I think provided occupancy is important.
No, I only can.
Yes.
So if I was to lease that park in total.
Yes.
I'm not talking about the leases to the tenants who come under the residential.
Oh, yes, like,
I'm not talking about that. If I was to lease the whole premises,
right.
would this act apply? The park does include a little shop, a kiosk, a general store.
I would have thought so.
So does the top act apply to the whole premises?
I would have thought so. I've just off the top of my head, I would have thought so. Because it's business premises. Which is sold to the public by retail. And it's doing that.
Well, if they're long term.
No, but you're leasing to a tenant to walk away from the park.
Yes, I can do that. At the moment, I already sell.
Sure.
Yeah.
And there's a shop, the kiosk thing, there's the public required to attend. Are they negotiating or are services supplied to the public? Probably. The services being probably accommodation type services. I would just, I don't know, it seems to me that it would. Struggling to see why it would.
You only provide it to people that have long-term leases. That's considered public.
Yeah, but the step involved we're looking at here is your lease to the tenant, not any residency of occupancy.
No, that's the legislation.
So, off the top of my head, I think if they are supplying a service to the public, which I think they probably are, probably retailing as well, I've thought some insurance. Yeah, I think so.
Mark, just given the general economic climate that we're going through, what are the top 3-4 complaints that you're seeing that landlords have to address, or they're getting pushed to address because of the economy that we're going through at the moment?
Yeah, well, COVID, obviously, I have a comment that brings substantial reductions to just so lots of COVID stuff. But beyond that, the arguments would be around council rent increases, I guess, obviously. The changing nature of retail space, that is the effect that internet sales have had on retail trade, walking trade. Shopping centres need to sort of change that to that. So their pressures on them are to adapt centres to their destinations. Choose where you get those. So that sort of thing, and some money needs to be spent to do that. That requires financial ability to repurpose these big centres, which otherwise may be the big stream. But the common operators are doing that. The arguments we've had are landlord obligations on capital those things. But that's a good thing. But the internet sale thing, that's probably the sales. Which place do they want to go?
So for outgoing as part of the lease agreement, the tenant actually argue or challenge the landlord to to ask for evidence of the insurance premium with them. And within the lease addendum or the clauses, there isn't a requirement to provide that. And the tenant also asking whether they can do their own insurance coverage for the building, and wasn't that covered as well. So what's really the landlord obligation on that?
Sure. So I think on the question of evidence, I don't think there's anything specifically about that, but it does need to be disclosed in the disclosure statement as to what insurance premiums are. And that implies that there are penalties for misrepresenting. Does that mean the landlord has to provide a copy of the premium? No, that's probably not. It has to be accurate. If the landlord were to issue a premium notice or issue an invoice for insurance premiums, it's agreed with, then ultimately the tenant would go to the small discretion and the small discretion say, we've got to prove it. So yeah, there'd be remedies for that. As to the ability for a tenant to take over what's being building insurance, he doesn't really have insurance. I mean, we wouldn't want to have his building insured by the tenant. And we will always insure his building. There are public liability risks that the tenant will have insurance for. And the tenant will likewise complex the net lease, gross lease, or sort of burying the rent, but he'll have a extra reimbursement of that premium cost. But it's always the insurance. That provides a moment on an interesting matter in which we're able to get insurance for what a very large auction. Tenant book auction brand, but the landlord costs insurance. It's his land. The landlord collects the premium. So it's not the landlord will hold insurance over to the
So is it worth putting a provision in to say you had a warehouse, just had it just as storage to tenant, so there's no service or goods offered. And then in halfway through, so there's this office warehouses that you use, so you could technically open it. Say you did the lease, so it's not, that doesn't apply, but you have to have it. Would the lease kick in if they started opening to the public? So started, I don't know, selling stuff in their warehouse, for instance, or yeah.
become a retail property. So you might want to restrict that if you're a landlord.
Yeah.
So that's sort of breach of this.
Yeah.
So you have some breach. So the whole question about whether you make retail sales is different. You have to make 1,000 retail sales. People stay behind. So, thank you very much for attending.